start. We have 45 minutes for this presentation. So hello everyone. I'm Kyriakos Fontokakos. I'm a partner at HSF Kramer based in Brussels, where I've been for the last 17 or 18 years, I think. Before that, in a previous life, I used to work for DG Comp as an official in the mergers department, and I've also spent a bit of time at the European Court, the General Court in Luxembourg, so that's me. And I will introduce my fantastic panel of speakers that will take us through the topic of today, which is information exchange in a complex setting. And we will be talking about a number of different, information exchange scenarios. So I'll start, and I'll go that way. So Francesca Mora is a partner in our Milan office and deals with a lot of M&A and antitrust in the M&A context in particular. And Francesca will be talking about issues that arise in the due diligence context in an M&A transaction, more specifically. Then we have Laurence Barry, a partner in our Paris office. Laurence joined us very recently, so new at HSF Kramer, but by no means new to competition law. She has a lot of experience in dealing with all aspects of competition law, from M&A to investigations and litigation. And she will be taking us through, in particular, the topic of hub and spoke exchanges and price signaling, which is quite a topical issue at the moment. Then we have Camille Puech, a partner in our Brussels office. And Camille is also an antitrust specialist who covers the full range of competition matters, and in particular has dealt with a lot of cartel investigations over the years, which include information exchange in particular. And last but not least, we are very happy to have with us Mar Garcia. Mar is the head of the antitrust and compliance group, basically within Menarini, one of the Italian pharmaceutical companies. And she will be giving us the in-house perspective. Mar also, like me in a previous life, was a DG Comp official in the mergers department, I think also Mar. And she will be talking about practical issues that arise in-house. So that's the way the agenda will go. We will start with some recent developments, in particular the Delivery Hero Glovo case, and then we'll go to the hub and spoke, due diligence and information exchange in that context, and then compliance from an in-house perspective. And just before I hand over to Camille, who will talk about Delivery Hero Glovo, I mean, the reason we decided on this topic, for this year's event is that it is really a hot topic in competition law. It's not new. Information exchange was always a difficult issue, and the European authorities in particular, more than other jurisdictions around the world, were always focused on information exchange and treated in some circumstances as a by-object infringement. But we have seen a renewed interest, in this area with high-profile cases like Delivery Hero Glovo, which resulted in a really high fine of 300 plus, million euro. The Portuguese banks case that Camille will also talk about, recently coming out of the courts, and increasing interest and focus on more complicated gray areas of information exchange. So not directly between competitors, but sometimes via price signaling, hub and spoke, like really more gray area stuff that the European Commission is really focused on. And Maria Jaspers, the head of cartels at DG Comp, has talked about this quite a lot in recent years. So, Camille, to take us through that first topic, over to you.
Thanks, Kyriakos. I hope everyone can hear me well. So I'd like to cover two developments at the EU level, which happened over the last year and a half. The first one is the Portuguese bank's ECJ preliminary ruling that dates from July 2024. So the facts underlying this case is a decision by the Portuguese Competition Authority in September 2019, where it imposed a fine of 225 million euros on 14 banks in Portugal for having exchanged commercially sensitive information. So the exchange in question lasted for more than 10 years, and so the banks would exchange on a monthly basis their current and future commercial conditions, including credit spreads and risk variables. And what is interesting is that the Portuguese Competition Authority found that this was a standalone information exchange. So it was not, there was no underlying price fixing or market sharing agreement. All they did was just to exchange that information on a monthly basis for more than 10 years. And it found that this was a restriction of competition by objects, because it was sufficiently harmful to the normal functioning of competition in the market. So most of the banks appealed to the Portuguese Competition Court because they said, well, look, that cannot be a restriction of competition by object. It's not sufficiently serious, and so the authority should have shown effects. And so the Portuguese Competition Court decided to stay proceedings and referred questions to the Court of Justice. And the main question was whether, and if so, under which condition, a standalone information exchange can constitute a restriction of competition by object. And so the Court of Justice handed down its judgment in July 2024, and it said that yes, under certain circumstances, a standalone information exchange can be a restriction of competition by object. And the court explained that under the normal conditions of competition, normally each market player should act completely independently and determine its policy independently in the market, and should be completely uncertain as to what moves its competitors are going to make. And it explained, or the court went on to explain that where you have an information exchange that is a form of coordination that that makes this uncertainty, that can remove this uncertainty in the market, then that may restrict competition by object. And then it said that in circumstances where the information exchange, related to sensitive, confidential information, in the sense that it would enable a market player to know what behavior its competitors were going to take, then that could be a restriction of competition by object. And in relation to the facts, to the very facts of the proceedings, the court noted that that could be the case, although it is for the Portuguese court to decide ultimately. The ECJ noted that in the present case, because the information that was exchanged related to credit spreads and revealed the future intentions of each market player as to how they were going to alter the credit spreads, and credit spreads are an important parameter of competition, then that could potentially indeed qualify as a restriction of competition by object to exchange that information. But now it's for the Portuguese court to decide, so we don't know, but that judgment is quite interesting because I think it shows that you don't need an underlying agreement, just exchanging competitively sensitive information can be a restriction by object. You don't need to show any effects. The mere exchange is sufficient in certain circumstances.
And maybe coming to say here, I alluded this at the beginning, that in other jurisdictions, I think in the United States, but some others in the world, you do need some underlying agreement. So the information exchange is normally an accessory to something that has been decided, or some collusive effect, and the information exchange is just an aid to the aims of that agreement. But in the EU is one of the strictest standards, and that has been now shown clearly by that case.
Exactly. Yeah. And the second development, which I'm sure you've all heard about, is the Delivery Hero Glovo decision of the European Commission from June of this year. So in that decision, so what happened is that Delivery Hero acquired a minority non-controlling stake in Glovo in July 2018 of 15%. And following that, there were... Yeah? Closer? Yeah. Oh, yeah, you're right. And following that, a whistleblower provided information to the Commission. A competition authority, we think the Spanish, but I think it's not clear, provided also information to the Commission, and the Commission did a market monitoring exercise. And then following this, it decided to conduct dawn raids at the premises of Delivery Hero and Glovo. And it opened a formal investigation in July 2024. And what it found is that Delivery Hero and Glovo had engaged in a cartel that consisted of 3 different elements. One of them was information exchange. So it found that for that period of 4 years where Delivery Hero held a non-controlling stake in Glovo, the companies had exchanged information as to their current and future pricing, as well as their current and future commercial strategies relating, for example, to the launch of new offers or the product characteristics. And the Commission found that this was, that enabled them to align and to influence each other's respective market behavior. So, of course, that was problematic. The decision is also quite famous because that's the first no-poach decision of the Commission. So the Commission found that in the shareholders' agreement that was entered into at the time when Delivery Hero acquired the minority stake in Glovo, there was a clause in the agreement that prohibited each company to hire certain key employees of the other company. And then this agreement evolved into a wider agreement not to approach each other's employees, so broader scope ultimately. And finally, there was also a market sharing aspect where the companies decided to divide the markets for online food delivery between themselves in the EEA. They also decided to remove all overlaps between themselves, none to enter a market where the other one was present. And for the markets in the EEA where none of them was present, they decided which of them would enter. So all of that was found to be an infringement of Article 101, and that resulted in a fine of 329 million on both companies. I think Delivery Hero got about 2/3 of that amount, and Glovo 1/3. So yeah, that's it for the latest.
Thank you, Camille. And just a question then on this case. I mean, you mentioned there were 3 aspects: the no poach, and it's quite famous for that, market sharing, and information exchange. Do you think that the information exchange part is sufficiently distinct that the Commission would have done it, let's say, just with that?
Probably they could. I mean, there was a lot of things, so it was not just information exchange, but if they had wanted to, they could probably have done also, have found an infringement just on that basis, because it was quite a textbook case of information exchange. And also, I forgot to mention, but the fact that Delivery Hero had a minority stake in Glovo was also found, to have facilitated the infringement. And certainly on the information exchange front, that has been the case. Because as a shareholder, they were also getting a lot more information. So, yeah.
Can I chip in? I'm doing something that I shouldn't do now, but because I think it's interesting to raise it now, because we've seen also, you said that the EU is having a very strict stance in terms of information exchange, but we've seen it, at least from my in-house perspective, also other authorities really looking into this very carefully, like Turkey, for instance. And we have cases because the Delivery Hero Glovo was within the shareholders agreement that then eventually was an acquisition of full control, but also without the backdrop of the acquisition in the case, and where we've seen these sort of investigations. Competition authorities are really looking into the HR world. Even if there is no agreement, they are looking into any information exchange on the part of employees or general managers. So even as a standalone, without the non-poaching, non-solicitation part, we are seeing that they're going towards that direction, and it's hard for companies and for in-house lawyers, at least that's how I feel, to take control, take ownership of all of this, because plenty of this information is shared on the public domain. Because, for instance, it could be employees talking about company benefits or salary increases against inflation, high inflation rates. Companies gather this information, and of course they've obtained it from public sources, but then if they cannot demonstrate that this all comes from public sources, this can eventually be a problem. So this is also something that that I am seeing in-house, and that it links to the Delivery Hero Glovo. But even as a standalone, they would look into it very carefully, I think, especially in the HR world they're picking up.
Great. So indeed, it is a hot topic, and we will now continue with perhaps, I don't know, grayer areas of information exchange. Laurence?
Thank you. So, yeah, the Delivery Hero Global case is obviously in the context of a minority shareholding. It should be much easier in the context of JV, because obviously JV are normally considered to be part of the same undertaking with their parent companies, so Article 101 does not apply, and that's the end of it. What we see as practitioners is that it's not necessarily the end of it, and there are at least two issues that I wanted to mention today that may arise in relation with exchange of information in the context of a JV. The first, obviously, is the issue of coordination between the parent companies. If they remain competitors in the market, the JV must not serve as a canal to align or coordinate their behavior. And we had, for example, a recent case where a non-full function JV was buying important inputs from its parent companies. And in that case, obviously, the parent companies remain competitors in the upstream market. And it's very important in practical terms that the JV ensure that it does not provide information to one parent companies about the price or commercial terms or whatever of the other. Another issue that may arise is the opposite, where parent companies may have JVs in the same markets with different partners. In theory, you would think, because the JVs form a single undertaking with their parent company, they should be able to exchange information. But because they also form a single undertaking with their other parent companies, this would mean for the information to be disseminated to third parties as well. And so if those third parties are competitors, that could also raise issue. Those are the kind of situation that some national competition authority, including the French competition authority, is looking at very closely. We don't have real decisional practice yet, but it's important to keep in mind. And for me, it's even more important to keep in mind because these situations are actually not very different from what is much more clear-cut today, which is the hub-and-spoke situations. Because in the situation I just mentioned, basically, either the JV or the common parent company is serving as the hub to pass on information between competitors. Hub and spoke, you know what that is, it's on the slide. The principles that govern the analysis have been set out by the European Court of Justice. So in a case you may have heard about VM Remons in July 2016, so almost 10 years ago, the European Court of Justice ruled that a company breaches Article 101, and I quote, when that undertaking intended, through the intermediary of its service provider, to disclose commercially sensitive information to its competitors, or when it expressly or tacitly consented to the provider sharing that commercially sensitive information with them. In addition, that's the ANIC Partecipazioni case law. Once the information regarding competitor A has been received by competitor B, that competitor B is deemed to take it into account in that market behavior as long as it remains active on the market and has not either publicly distanced itself from the conduct or reported it to the authorities. So that's the theory. For a long while, it remained theory. But in the past years, we've seen concrete application of that by the national competition authorities. One of the most detailed analyses of hub and spoke has been done by the French Competition Authority in 2020 when it looked at a possible hub and spoke between Apple's French wholesalers. That's case 20D04, issued in March 2020. And in that case, the French Competition Authority found that the wholesalers actively sought to receive information about their competitor from Apple so that the Ramon's criterion was met. And the only reason why the objection was ultimately dismissed is because the court found that even though they did obtain information about the competitor, that information was not sufficient to have a real impact on their behavior on the market. But they really applied the Ramon's criteria in that case. And in 2022, the Dutch Competition Authority, followed shortly afterwards by the Belgian Competition Authority, actually fined cigarette manufacturers for a hub-and-spoke infraction using their wholesalers. The authorities found there was an established system in place through which the price lists that were communicated by the cigarette manufacturers to their wholesaler were immediately passed on to the competitors by such wholesalers. And obviously it was worse because the price of cigarette is fixed by the manufacturer itself, so that was directly the retail price that were communicated to competitors. So even though Herbert Spoke for a very long time was a bit of mythical animal, it's not anymore. And the same is true for price signaling, because price signaling is a theory that started a long time ago, especially in the US. They had a U-Haul case in 2010 where a company announced during an investor conference call, and we're going to talk a lot about investor conference call, that it had recently increased its rate and it invited competitors to do the same. That was considered an infringement, although in that case there were also more direct exchanges between the companies, so not a pure price signaling case. Then there was a try by the DOJ to find Airbus and Boeing liable for public statement made by Airbus COO in the early 2010s that they were aware that Boeing would not be happy if their market share increased above 60%, and that they would take that into account to avoid a price war. But that didn't really lead to anything else. Then we've had a number of national cases that were resolved through commitments. So not very lengthy decision, but still very interesting. We have a first case by the ACCC in Australia, where information disclosed through a petrol price information exchange service, that provided prices in real time, was considered a possible infringement. And they took an interesting commitment, which is they said, we're not going to stop that, we're just going to make the information public to everyone. So actually, consumers can also see the price in real time. And the ACCC said, okay, that alleviates my concerns. We have a Dutch telecom case in 2014, where the information was disclosed during industry conferences, so much like this one. And it's an interesting case because the Dutch agency considered that price signaling was actually an infringement because it found evidence that it was clear for the competitors receiving the information that the market leader was trying to signal something. So it was not just a nice chat between experts. It was actually found that they were looking to the market leader to issue an invitation to follow a certain course of action. In that case, the commitment was to not discuss price increase publicly until the price increase had been announced to consumers. Another case in Norway in 2020, that time it was disclosure, unilateral disclosure by trade association, hinting at what their members would do. And in that case, the commitment were limited to compliance program, so very, very small commitments. And you had another case of in Ireland in 2022 in the insurances. So, and again, commitments limited to stopping the practice. What is more interesting today and why we wanted to spend a little time on price signaling is because there is actually an ongoing investigation by the European Commission, which is very interesting because for the first time, the Commission has actually bought data from a third-party provider, and they have bought, according to what they've released, hundreds of thousands of transcript of earnings call, and they used forensic to run that through keywords through all the earning call, looking for indication that they talked about either, both price increase and competitors. And based on that, they targeted the tire manufacturers because they found that they were very often during the earning calls using phrases like send a signal, we plan to, we have no intention, and mentioning directly their competitors. So Maria Jaspers has said it shouldn't be a concern because earning calls are normal and they should be, but the fact that the Commission has decided to buy all this data to look into it is definitely a strong signal that they are looking into it. And I think many of you in that room know that the AGCM, the Italian authority, is also looking at these issues. So it's definitely a hot topic. And sorry I've been too long.
Thank you, Laurence. And I think on the slide, we have the Milan case, which is the one I think you just mentioned. That investigation is, of course, still pending, but there is that order by the General Court on interim measures. I think it was about whether the Commission had sufficient indicia and evidence to launch, the investigation, the dawn raids. And the court said, yes, they did. So I think that is quite interesting, actually. We now have some judicial authority also that price signaling can actually be a problematic area. So I think many companies have taken notice, as you said, and it's really an area that they need to be quite careful with at the moment. So we will move on to the next topic, which is due diligence and competitively sensitive information exchanges. So, Francesca.
Yes, because in M&A processes, the exchange of sensitive information is always something very delicate because there's an inevitable tension between those people whose role is really to ensure that the deal happens in the smoother and quicker way possible, and those who are involved in the deal but of course need to ensure compliance with the law, including of course competition law. Now, exchange of information in the context of acquisition processes may have of course impact both with respect to the gun jumping risk, but also anti-competitive behavior. Now, the competition authorities, of course, understand, appreciate that there's a legitimate purpose of the buyers to acquire information, to have a proper assessment, a proper evaluation of the target companies. Therefore, it's something ordinary in any kind of M&A process. But the question is, what is necessary and proportionate to exchange in the context of an M&A deal. And this is the practical challenge that we as practitioners and in-house counsel face basically in all M&A processes. The European Commission horizontal guidelines provide some guidance. We also have case law, for instance, with respect to the gun jumping, the Altis case, which set out what kind of information can be more sensitive, but the key message for me, one of the key message that I find it very useful in practical terms in M&A processes is the evaluation of the nature of information, also depending on the stage of the process. So there's a tendency of let's say M&A teams or financial advisors, M&A advisors to provide whatever information as soon as possible because it is believed that the buyers need to have as much information as possible very quickly. But this is absolutely not really a best practice. This is what we suggest actually not to do, because in every stage of the M&A process, the legitimate purpose and what is necessary and proportionate, which is really the key question that we need to address, differentiate. This is especially the case when we have bidding processes, so many potential buyers, which of course is different when you have a final process of the M&A with one single buyer. Then the other what are the mitigants are well known, so aggregation of information, anonymization, but probably the most useful tool is the clean team, the creation of clean team, which is of course also suggested by the European Commission in the guidelines. Now, from a practical perspective, what could be really easy, let's say, to read on papers can be a little bit difficult in certain situations where the buyer may be not so structured or sophisticated, because in the end, people who should be in the clean team, so the one who needs to receive the information to evaluate for a proper assessment of the target, are really the one involved also in the operations of the buyer organizations. And therefore, the clean team is not really the solution, because it's something which may not really function in certain circumstances, especially, for instance, in the Italian market. We know that let's say many companies are small or medium enterprises, so it's a little bit difficult to create appropriate clean team. And then we go back to the nature of the information, the way to exchange those. And again, the Altis case provides some guidance. This was again on the gun jumping, but the concept is the same. So in that case, the issue was, of course, the level of detail of information, also the fact that in addition to the financial data, which are, of course, are necessary to evaluate the business, the company, there were also future strategies, financial data, budget planning, key performance ratio, also on the future. And now, just to complete, one of the counter arguments, let's say the argument of non-competition people of the team involved in the M&A is, well, but in the end, this is a problem of the seller, who should be careful not to give sensitive information. The buyer or the bidder, it's simply receiving. So what's the issue? And of course, this is not the case, because we perfectly know that also passive receipt is an issue, and therefore, I mean, in the context of the M&A, we covered the topic, but more generally, passive receipt can also be something very problematic, and the case, one of the case probably more interesting, although it's of some years ago, 2022 in the UK, related to Motorola and Sepura, one employee exchanging a message to one other employee with ring fencing of the information in the context of a public tender. So presumably no exchange of information within the recipient, but still the authority found a breach because there was no publicly distance from the by the recipient of these messages. So this case highlighted the importance of raise objections when it comes to passive receipt.
Thank you, Francesca. So that's a really good segue to you, Mar, to tell us you face these issues in-house.
I do. But to be fair, coming back to Francesca's area, it's not the easy, it's a complex area, but at least we are in control. I mean, we, the lawyers. So, I mean, it gives me some peace of mind because, you know, we are, at least I am from the outset, involved in the legal due diligence. So then we have the time to put in place the NDAs, the clean teams appropriately. So, I mean, it's complex, but still it's more or less under our control if we do it properly. I mean, and sometimes you were mentioning that the other side is has a different culture, so that sometimes is a bit of a hiccup, but we do work that way, so we put in place. I mean, the first thing that I always ask the team is to really understand what are we looking into. So is this an in-license deal for a product that we already, you know, we're already active in the same therapeutic area or in the same market? Because then it really marks the difference. I mean, are we entering something completely new that we have no presence whatsoever as of today? I mean, it's not that we're going to do things radically different, but I mean, it sets everyone in a different perspective in the due diligence. Sometimes what I've seen that is difficult is, okay, I mean, even if we have a clean team, we're going to have very sensitive information. But first, we need to figure out whether there are major risks that wouldn't make us go ahead. And what I've proposed and what we have proposed in the past is to do a staggered disclosure. So in the NDA, in the setup of the data room, etc., we first have documents that are heavily redacted, so that we can figure out first what the legal risks are. For instance, I mean, I'm thinking, to give you an example, if we are trying to in-license a product from another territory, but the licensor has not full rights, so they have another, upstream contract, we would want to look into that contract first, the termination, the rights, etc., to see if we want to go ahead, if we need data from a third party that they need to have the agreement in place with. So all of this would make the due diligence, at least in the first phase, you know, I mean, it doesn't necessarily involve commercially sensitive information, and then we can avoid all the issues of having had an early disclosure. So, I mean, something that I do is propose this sort of staggered due diligence when possible, if possible, and when it makes sense, of course, to do this first filter with a partner or a potential deal whatsoever. So I think that was, you know, my take on your area, which I said it's easier in the sense that we are involved, but it's really complex. Coming back to the information exchange, and I was mentioning earlier, sorry that I jumped in, but these authorities being very interested in new areas that they were not interested, at least, I mean, I'm not super old, but so far the last 20 years I hadn't seen many cases in the HR space, as we are seeing now, not just in the EU, but, you know, I mean, there is the US, completely different story with the non-competes, but I mean, in Europe and also in other jurisdictions like Turkey, they are really looking into this, and in fact, there, the information exchange may be really like, just a passive receipt of information, or, that the company didn't distance itself or didn't clearly state that this was coming or that the information was coming from public sources. So, this is nothing really, really new, apart from the developments that you have mentioned. But I think it's really, really a hot topic now for companies, at least in my space, in the pharmaceutical space. It's very important, because we do have, apart from the HR part, we do have loads of partnerships. And I guess that happens in many other areas, but you have plenty of legitimate contacts with your partners, and that's where the complexity comes in, because, we are the experts, but most people in a company have a very vague idea or very vague grasp of competition rules. So sometimes they don't even know that, they are transmitting some information to a partner within a legitimate contract, etc. They don't even realize that this could be a risk, or that it could be an issue down the line. So there, we're less in control, but I think that's when we need to really implement a culture of compliance, try to make people understand at least the basics of what the risks are in the information exchange, to ask everyone in terms of, having policies in place, whatever you may, antitrust compliance programs, call it whatever, but to have means to somehow make people responsible for what they disclose, because you were mentioning, Laurence, that the fact that they're now using super advanced forensic tools, but also communications go everywhere and anywhere, so we cannot control everything that's going on in the company and how people are discussing with partners. So having in place policies, explaining really well what the risks are, and especially, I think, having the teams really sticking to what the contracts say, because I've been in situations in which, not even the partner itself, but maybe a member of the consortia asks for information from us. They are, commercializing X in South Korea, and they want to understand what are we doing in Europe, and it's not even our direct partner, but there are information flows that, and the first thing I tell them is, do we have any contractual relationship with them? Are we bound to provide any such information to our partner, to our licensor? Please first check the contract. Anything which falls outside, we should not disclose. And if there are, of course, doubts and gray areas, they have to come to us, to me. But I think this is a very complex area, because indeed it's not just relying on us, the lawyers, or the in-house, the external advisors. So that's my take, but I don't know how we are in terms of time. So to give time for questions.
I think we are at time, but thank you, Mar. I think it's really fascinating to hear it from a really practical, kind of in-house perspective on the issues that arise with the business. And as you said, Francesca, in Italy, for example, you have a lot of small and medium-sized enterprises. Not every company will have a good antitrust lawyer, in-house to give that advice. And then it becomes really tricky, and, issues can arise. I think maybe I'll summarize it, and we can open the floor to some questions, maybe for 5 minutes. That what comes out is these are really complicated areas, and as you said, sometimes the business doesn't know that it's really something problematic. So I think the two questions normally to ask, right, as lawyers is, why are you doing it? Like, what's the rationale for the information exchange? Is it legitimate, yes or no? And if it is legitimate, then the second question is, how are you doing it? Can you do it in another way that perhaps has more safeguards in place to preserve some of the anonymity, etc., of the information? I think these are the two key points, to ask the business, in my view. But we'll stop here because we are exactly at 4 o'clock now, but maybe we can take 5 minutes for questions, if there are any. No? All clear, so thank you. So we run this as a Japanese Shinkansen train to time. It's 4 p.m., so we can all go for coffee or the next session. So thank you very much for listening to us.